Hi, this is Jessica Leal from the Committee on Federal Courts for the CLA. At this point, Northern and Southern District have issued a number of general orders and held online events to further explain how the courts are operating in this environment. Those are obviously very helpful, and we assume that many of the people watching this are familiar with those orders. However, now we wanted to take some time to take a more personal approach and speak directly with some of our judges about how the new COVID-19 pandemic is affecting the courtrooms. We want to know how this is affecting chambers, what has changed the most, what has maybe stayed the same, or how we can help our judges too and understand what's going on behind the scenes. Before we start answering these though, I'd like to introduce our speakers. From the Southern District, we have Judge Sabraw and Judge Burkhardt, and from the Northern District, we have Judge Gonzalez Rogers and Judge Beeler. With that, I'd like to introduce one of my colleagues on the committee, Christian. Christian, I had it all. With that, I'd like to introduce my colleague on the committee, Christian, Andreu-von.
Hi, so judges, why don't we start with one of the points that Jessica just raised, and why don't I begin by asking you what you think has changed most since the shelter-in-place orders were put in place? Why don't we start with Judge Sabraw?
Well, thank you, and I'm just delighted to be here and be with you. It is a very interesting time and unique time, and I think one of the very, very positive things about all of this is our court is working closely with our Bar Association, many of the stakeholders, and it's really a time where we've come together. So it's an unprecedented effort, and we're getting a lot done. I think what's changed the most, just from an everyday human perspective, is there's a lot less people in the courtroom, and the vast majority of people in the clerk's office and in chambers are telephone. I would point out two other fundamental changes. One is all jury trials have been suspended in our district. They were suspended effective March 13, when the national emergency was declared. And we've been suspending those trials from month to month. So our proceedings are suspended through mid-May, and I anticipate that we'll continue that suspension into June. The other monumental development that is unprecedented in the history of our courts is video telephone conferencing for criminal defendants, those accused of crimes. They are entitled to be personally present during most proceedings, and it literally took an act of Congress through the CARES Act to pass a provision that allows those accused of crime to appear by BTC. It also required the Judicial Conference of the United States Court to make a finding that in-person hearings would seriously jeopardize public health. So it's an extraordinary development, and through BTC, with the defendant's consent to appear by BTC, we have been able to adjudicate many, many changes of plea and criminal sentencing. So it's really advanced our ability to handle those kinds of cases.
Well, why don't we stay in the Southern District to see if Judge Burkhardt, do you have anything to add?
Yes, in addition to the things that Judge Sabraw mentioned, as a magistrate judge, one big impact is that we are not having in-person settlement conferences. So in the Southern District of California, in addition to mandatory settlement conferences at the end of the case, we have early neutral evaluation conferences at the beginning of almost all civil matters. And those are generally conducted in person. And currently, we are not having parties and counsel come in. So we've converted to holding those either telephonically or by video through, personally, I use Zoom. And I think that's the only video conferencing that we're currently using in the Southern District. But that's been a big change. And I think the parties are very grateful for it. They are happy to be able to continue with taking advantage of the E&E process without having to endanger themselves or violate any of the state or local prohibitions. And I found that they are very, very effective. So for example, personally, I've had 6 early neutral evaluations since April 1st, either by video or telephonically in non-class action cases, and every single one has settled. So I find that people are very receptive to the involvement of the court and getting cases that can be settled early, particularly in these very challenging times.
Why don't we move up to the Northern District? Judge Gonzalez Rogers, do you have anything different or the same up in the Northern District?
Well, it sounds like much of what's happening in the Northern District is as outlined by Judges Sabraw and Burkhardt. I would say a couple of things that may or may not be different. I don't quite know how it works in the Southern District in terms of accessing their criminal defendant population, but in the Northern District, we had virtually no ability to communicate with our defendants. And so they are currently in a county facility. Some districts have their own federal facilities, we do not. And so we not only have been collaborating with our institutional partners, our federal institutional partners, but with our county counterparts in order to get access both by telephone and by video. Now our video access only exists on the weekend. So to the extent that we want to have video conferencing with incarcerated defendants, that's only happening on the weekends. And I'll let Magistrate Judge Beeler talk about what's happening in magistrate court, which is, it is a feat. So we have been working every day to make sure that people's constitutional rights are protected and to give access to the courts by that group. Nothing is happening in our courthouses. I mean, we have skeletal staff to process mail. I think some of the things that the lawyers really like is that we eliminated all courtesy copies. And so there is a lack of paper, but we are using volunteers to come into the courts and help with that from a staffing perspective. There are some judges who are operating out of chambers. I'm here in my courtroom. We use, in March, we did obtain licenses for Zoom, and many of us, I would say the majority of us, are now becoming much more familiar with the platform. So we do meetings for internal issues and for public events such as case management or law in motion. We are using the webinar feature of Zoom. So I've already, I was mentioned earlier, I was to the panelists that I've used it now for a tutorial and a patent case. I have 2 more tutorials and 3 Markmans scheduled for later this month. I will be doing all of my criminal out of custody by Zoom, civil law in motion, case management conferences, and that's new and different. Never have we had this option available to us. It's not perfect, but it is certainly, in my view, much better than the telephone. I like to be able to see people, to see how they're reacting, to tell them to stop. They can see my eyebrows go up. You know, it's much more interactive to be able to see people on the video. And I did have one lawyer who said, you know, I haven't put on a suit for so long. Thank you for doing this. I never thought I would be so happy to put a suit back on. So perhaps it's also helping people to, you know, kind of deal with their day in a slightly different way because they actually have to appear on a video conference with a judge. So I would say those are the kind of differences and similarities between the Northern District and Southern.
Judge Beeler?
Well, to echo that comment, on the civil side, I will say the interesting difference, in addition to those described, is that things take much longer. So, and it's just not as easy. So as Judge Gonzalez Rogers described, how we're all moving towards our civil trial calendars by Zoom, which is great. You can see people and it's much better than the telephone. When you have a big case with lots of people in it, you can't manage it on the telephone and you cannot do as good a job. So it's wonderful that we're moving to Zoom. And for example, I have a class certification motion coming up in one of my antitrust cases on my trial docket. And it'll be great on the one hand, because I could have experts testify from the East Coast and lawyers display exhibits. But the seamlessness of an in-person experience is gone, and it takes more work setting it up, and it takes more work doing it. And to move to the criminal side of it, all of that is almost nothing because it is relatively efficient. All of that is almost nothing compared to the inefficiencies that now attach to the criminal calendar. And I'll just touch upon them briefly. But again, Judge Gonzalez-Rogers and her task force team have done an amazing job getting us back up and running as close to business as usual as possible. The lawyers have been great about being accommodating because we've not had the ability to have the BTCs for the in custodies except for on weekends. And so we don't have that ability with the duty calendar. But what used to take an hour now takes 5 or more. All the paper too is being submitted electronically. I don't think anyone will ever want to go back. There are some great things that we've learned from these processes. I think that we're able to be more accommodating with access by video. In some ways, we're able to open up the courts in a different way than we have, and I think that's a positive. But I think just understanding, especially on the criminal side, how much more time it takes than it used to, and because of that, civil trails. And so it just is. It's an amazing thing that you used to be able to spend about an hour on what now takes 5 or 6. We have telephones with serial participation by folks at Santa Rita, which is our county jail where we house our in custody defendants. And I applaud the marshals and their ability to make it work, and the jail staff, but it is tedious and it's time consuming.
I will echo that, even though we do have the luxury, and it does sound like a luxury, of being able to do video conferences with our criminal defendants. We're very limited in the capacity. So we have a maximum of 3 judges who can hear criminal matters at any given time. It has to be coordinated which facility each judge is accessing the defendants from. And we, again, many of our criminal defendants are not English speakers. And we've been very spoiled. We have an absolutely phenomenal court interpreter department. And we've become spoiled. We're used to simultaneous interpretation. You can't do simultaneous interpretation when you don't have the interpreter in the same location as the criminal defendant. The defendants are wearing masks. So as a judge who has to assure that their participation is knowing and voluntary, it's an added challenge when you're seeing a defendant, but you're only seeing their eyes most of the times. You're going through serial interpretation, and everything is very, very slow.
By the way, we would love to have 3. We have 1 line. That's all we have.
Yeah. And your caseload in the Southern District is so substantial, and it already was an all-day task, and I'm sure the burdens are considerable.
It is substantial, and I know that maybe this is a good time to segue. I know Judge Sabraw is going to talk about how the court is prioritized, but I will say one piece of that is the U.S. Attorney's Office has been very scrupulous about analyzing what cases they file, what cases they can address through administrative or other non-criminal paths. And for those where criminal charges are brought, they are really, to the extent possible, consistent with public safety, giving notices to appear rather than arresting people and booking them into custody. That's gone a long ways, in addition to other steps that have been taken in reducing the prison population. Also, it reduces the number of defendants who need to have their first appearances handled on any given day. Unfortunately, it's sort of kicking the can down the road, because the people who are being given notices to appear, those notices to appear continue to be extended out as the crisis continues. And when we are able to accommodate those criminal defendants appearing in court, finally, there's going to be a great overwhelming press of first appearances to handle.
I should add, on the criminal side through BTC, the way we have processed this, we're working very closely with the U.S. Attorney's Office, federal defenders, and our CJA panel attorneys. And we initially identified a number of cases that there would be a joint recommendation for time served sentences. And obviously, the goal was to adjudicate those quickly and to move those persons out of BOP custody. Through that and through the U.S. Attorney's charging decisions and notices to appear, the case filings are declined substantially, and we have reduced the BOP population by over 1/3. So it's really worked. We've done it in 3 phases. The first phase, we had identified almost 200 cases that would be adjudicated through time served joint recommendation sentences, and we did that. We had, as Judge Burkhardt mentioned, 3 district judges in the morning, 3 in the afternoon on Monday, Wednesday, Friday, and we got through all of those cases in phase 1. In phase 2, we had the parties make recommendations, the defense bar, those cases that they believed in good faith would be subject to a time served sentence, even over the government's objection. We queued those up, and we've gotten through all of those cases. Now we're into a phase 3 where we're continuing to handle criminal sentencings, those that are ready, and we're moving into other areas, motions to dismiss, bail modifications, those kinds of things, so we can begin to address all of the law and motion matters related to criminal matters. We're also encouraging the attorneys in law and motion matters where they only raise legal issues to waive their client's presence and to appear telephonically, and that way we can address a number of these motions promptly.
How many folks did you have? You mentioned 200 in phase 1. How many do you have in phases 2 and maybe you can guess in phase 3?
I don't have a number. For phase 1, it was 190, right about there. Phase 2 is a little different in that each district judge maintained their own cases on their docket. And then each judge made a determination whether that defendant might be subject to a time served sentence. And if so, he or she would put that case on their calendar. So I don't have a specific number as to how many we've gone through. I just know from our weekly judges meetings that we've tended to those cases, and now we're moving more generally into open sentencings.
Yeah, I think what might be a little different for us is obviously we don't have the access that has been in the Southern District. We were able to, through the CARES Act, able to do quite a few sentencings over the telephone. And for credit for time served sentences, defense lawyers were waiving appearance. And to the extent that the judge was inclined not to give that sentence, then those were being put over so that the defendant could then appear telephonically for those particular proceedings. Through the that phase of sentencings and just the BOP transport moving prisoners out of Santa Rita into BOP facilities, we've reduced our federal population by about 20%. So that's helpful, but we've been advised by the U.S. Attorney that, you know, whereas crimes or criminal activity had been in a lull during this first phase of the shutdown, they are seeing a rise again. And so we are anticipating increased filings. They are asking us to consider some alternatives to arrests like a summons, so that we can do the kinds of things that Judge Sabraw has been talking about and not have people just sent out to the jail facility. But that is a phase yet to come. And again, I think it's really helpful when the institutions have a collaborative working relationship, because, you know, we can start preparing for these things and we can see what's coming down the pike. I mean, our court has ceased all in-court proceedings through the month of May. So we are looking to what a June reopening would look like. And we're just now in the process of trying to figure that out and what those phases would look like. And certainly, I think the institutional players are interested in having in-court pleas and sentencings, and the judges certainly feel like they would like to have those in court. And the question is, you know, can we do this in a phased way so that we can have some people in the courtroom, but perhaps others watching remotely and staff watching remotely, because, you know, unlike the corporations of the world, we can't just write a check for protective gear, even if you could get it, or you know, barriers between our staff and the public. And so there are a lot of logistical details to figure out. But I think for purposes of the lawyers here in California, you should know we're kind of focusing on trying to make that criminal piece of the puzzle work before we roll it out to civil. I think in terms of our civil calendars, certainly appearances by video or by telephone seem to be working pretty well. It's a little bit different when you have to sentence someone. You'd like to have that person actually there in person. You know, these are all of the various kind of considerations we are weighing to figure out how we do a rollout. I heard Mark Benioff of Salesforce today describe this as, it's not going to be a turn on, turn off light switch. We have to think about this more like a dimmer. You know, we set something, and if it works, we increase the light. You know, you just kind of keep turning the knob one layer after the other, so we can make sure that we're doing things in a thoughtful and safe way, and providing access where we have lots of different people, both court staff and the public and the litigants, to think about.
With the priorities that have been described, is there already a concept of what types of proceedings and motions are just going to take a back burner?
Well, you know, what's interesting is you know, I don't know what you mean by back burner. Maybe I take issue with that word. I mean, our civil dockets are moving. You know, within, I think I was one of the first ones in the Northern District to stop in-person appearances. I did that, I think it was March 12th. The court, as a full court, didn't do it until the following week. But I was adamant that I was going to try and get things continuing to move, because in the Northern District, about 80% of our docket is civil, 20% is criminal. So once we got the Zoom licenses, you know, we were having proceedings, and orders are being issued and cases are being moved along. I think one of the questions was about continuances. You know, I've been very accommodating to the lawyers on what I would call a first round of continuances. You ask for 3 months. If you think that's what it is, I'm going to give you the 3 months. If you come back in 3 months and ask for another 6, well, maybe not. We don't know. It really depends on what the state of play is. But I do think we're all going to have to get a little bit more comfortable with video. You know, you may have to do your depositions by video, whether you like it or not. Otherwise, you know, if you read the science, we may be in this situation for 18 to 24 months. I'm certainly not going to wait that long. You know, cases have to resolve, and there are ways to do it. We're just going to have to be more flexible. So I don't know that I would say it's on a back burner. We've been working really hard to keep things moving. Just because you're not here in person doesn't mean that it's a back burner.
I think that's true also with the Southern District. Our caseload is probably about 30-35% civil, the rest criminal. So we're obviously focusing on our criminal sentencings and those adjudications, but civil is moving full speed. Like with Judge Gonzalez Rogers, all of the judges are maintaining their civil calendar. And of course, many of the cases are driven by pretrial orders. And so law in motion is a very significant component. All of my staff is telecommuting, but we are calendaring as many cases as we ever have. Civil filings are constant. Law in motion filings in my chambers have risen slightly. And we're handling all of those cases on time. We're very efficient. We are using telephone conferencing a great deal every afternoon, and it works very well. All the lawyers and parties call in on one line. We're also providing the media and the public access on another line. It's been regularly used. The media coverage is prompt, and so we're providing full access to the court and accommodating all of the rights of our civil litigants, and we're doing it I think, very efficiently and in a seamless way, albeit through a different medium. It is very different when you're in court and no one's there except for your staff and you're listening to everyone on a telephone line. But they're being heard and we're issuing our orders.
I'd like to follow on something that Judge Gonzalez Rogers brought up, because I think the practitioners really do want some guidance on the issue of continuance. And as Judge Gonzalez Rogers suggested, in the Southern District, I think in the first weeks that we were trying to figure this all out, all of us were granting requested continuances pretty readily. We wanted the practitioners to have a chance to adjust to the new normal. And now we're, a couple of months in, and our expectations have been reset a little bit. We do think that by now people have figured out some of the answers to questions about how to get depositions completed, how to address discovery issues. So now when I get requests for continuances, I want to know if there is something specific about that case, why a particular piece of discovery or whatever the issue is, why it couldn't be completed or can't be completed on the timeline currently in place. And sometimes it's very valid. You may have information that's only available in a particular laboratory that's become inaccessible for one reason or another. Let me know that. Be specific and explain what efforts have been taken and what the timeline is for overcoming the remaining obstacles. It's less persuasive at this point to say, oh, but we have all these depositions and we want to do them in person. Why do they need to be in person? If there's not a particular reason, then what steps have you taken to put a protocol in place to proceed with video conference positions? And if one aspect of discovery can't be completed, you may only get an extension with respect to that aspect of the discovery. We are looking, I say we, I am looking, and I understand my colleagues also are looking for that demonstrated due diligence, where efforts have been taken to complete things on time within the restrictions that people are living in.
Judge Beeler, we understand you've held some MSCs by Zoom. Can you comment on that process?
Yes, I have. Everybody kind of, for the first week or two even, I think people just ground to a halt. And I think they needed some space. This echoes what other folks have said, to just collect themselves. But since then, it's not quite back to business as usual, but it's pretty close. I think I worry. So we have all sorts of cases on our civil dockets, ranging from business disputes to torts, whether those are civil rights torts or otherwise. And certainly all the business cases are going forward by Zoom. I have my first civil rights Zoom settlement conference next week. The Northern District is a small town. It's sort of funny, and we do know each other pretty well. And so I have felt the ability to retain the intimacy of in-person settlement conferences on some level, because I know the lawyers in many cases pretty well. So, but yes, it's different. You lose something to that in-person attendance where people have a cup of coffee before you get started and you sort of build a feeling of a relationship. It's more complicated in a virtual setting, and we're doing it. I think we have to learn new ways of connecting, even if the connection is now by video conference.
Has anyone had any remote bench trials?
I know they're coming up. I don't think we've had any in the district now. I know Judge Chen has one next month. Judge Kim has one. I have one that they think it's summary judgment, but it's not. And so we're going to have to, there needs to be some testimony that comes in. So I think all of us have adjusted to the idea of having bench trials. It's absolutely doable on a video conferencing platform.
I think the reaction in the Southern District's a little different. I'm delighted to be part of this because I'm learning from my colleagues in the Northern District. I think your proximity to Silicon Valley has made you more enlightened and prepared for Zoom. I don't think any of my colleagues have done a bench trial, and I think very few, if any, are Zooming, at least on the district court level. I've been reluctant to do it, but I'm going to keep an open mind to that. And I think for lawyers who are watching, if you're in the Southern District and you want to proceed on a civil matter and you think it can be done by Zoom, you ought to let the court know and let your judge know what they're doing in the Northern District. I have continued my bench trials. And I've done it principally because I'm a big believer in in-person trials. But I can be persuaded otherwise. And then perhaps more importantly, in the bench trials that I have continued, I have had counsel with underlying health issues. So I had telephone status conferences with them, and I invited them to meet and confer. I let them know that the court was here, we're ready, and we can proceed and accommodate social distancing. We can do all of that. But if counsel are uncomfortable at this time proceeding in a bench trial, to let me know, and on a joint motion, I would continue the trial. And that's what's happened thus far. So far I've been accommodating, and we just kind of play it week by week.
And for practitioners who want to proceed by a Zoom trial, consider consenting to a magistrate judge. I think we're all more comfortable with it.
Yeah, I think Judge Beeler is right. I mean, in the Northern District, all trials were postponed until the end of May. So no one's even been given the opportunity to do it. I could envision doing it. My first bench trial is not scheduled until September. So if we're not out of this, given the injunction that I issued in the case, I think they're going to want to go forward, and I think we would be able to do it by the Zoom. You know, I'm assuming it's Zoom, but it could be any video conferencing platform by a video conference. I think that to Judge Sabraw's point, you know, some judges are more comfortable, and the more you use it, the more comfortable you become with the technology. And Judge Sabraw, I'll offer to you that if your law clerks want to pop into my Markman hearing on Friday, they're welcome to. It's publicly accessible, so they can see how it works.
I am one of the pilot judges down here, so that's a perfect opportunity. I appreciate that.
Or maybe we could do a joint session sometime. Maybe figure out if we have some case in common.
Yeah, absolutely.
I think we all prefer to be in person. It is easier. It is easier. In the cases that I've identified, the lawyers are asking for it, and I think we're able to accommodate it. And it's no different than having a Daubert hearing or something like that. So I think, but I think we all, the ease and the importance of in-person bench trials, that's huge.
You know, I think the real big issue is going to be jury trials and how we make those work. It's, you know, it's one thing to be able to, as a judge, we're so used to our forums, right? And we've evaluated people over time and for decades or whatever. But jurors need to see people, it seems to me. And I don't know how we do a jury trial if we're not doing it in person. And if you're doing a jury trial in person, you've got to protect those jurors. You've got to protect everybody who comes into the courtroom. You have to protect staff. But even before that, jury selection is going to be an interesting concept as well, because you have to have so many more people. I mean, I have a jury box that sits 14. I could probably put, in a civil case, I could put 8 in there or 6 in there without having them right next to each other. If in a criminal trial, I can't do that. So you have to spread them out. I mean, we've talked about, and I think people have to start thinking about the issue and giving each other ideas and brainstorming. For instance, I'm not sure we can do jury trials anymore unless we have multiple courtrooms available, because jury deliberation rooms aren't big enough to give people separation. We might have to have the jury in a courtroom, and where you're conducting the case in a different courtroom. You know, I wonder whether we have to use questionnaires more and limit the number of people who we bring in, and requires maybe the lawyers to do some measure of selection from the paper before we bring people in. What do we do with jurors who are in high-risk categories? Do we automatically let them out? Do we not let them out? I mean, there are lots and lots of questions that I think we as judges and lawyers in the bar have to start thinking about and talking about. And so to the extent that the California lawyers can have sessions on this, or maybe pros and cons, or ways to think and inform the judges about what we need to be thinking about, I think that would be a useful topic for discussion and collaboration. Because at least in the first instance, I think it's going to be different than it is now, or at least than it was.
The civil jury trial project out of NYU, I just got the Steve Sussman's project. They're putting together, over the next weeks, they're going to be making some recommendations on the civil jury trial aspect of things, but there's such important questions that you've identified, and that's the big thing. What's our jury trials are so important. But Judge Sabraw, you were about to say something.
Yes, I would add that our Chief Judge, Thomas from the Ninth Circuit, has convened a subcommittee, jury trial committee, and one of our colleagues here in the Southern District, Tony Battaglia, is on that committee. And they're working in earnest on this issue. It's a tough issue. We take our lead, of course, from the medical professionals, the scientists, and our local leaders. Right now in San Diego, you have to wear a face covering if you're in public. And the public's just not ready to come to a courthouse. It's too soon, but when the time comes, I think it's going to be a very incremental process. Judge Battaglia was saying, for example, what he's exploring. It's consistent with what Judge Gonzalez-Rogers had mentioned. We would start with criminal jury trials. They have a right to be present, of course, and so those jury trials cannot occur without everyone being personally present. And we would have to use a ceremonial courtroom or our jury lounge to pick a jury, because we would be bringing in 50 or so prospective jurors for the veneer and pick them in that setting. Once the jury is picked, we have 12 deliberating jurors and 1 or 2 alternates. They would be brought to our courtroom, and then we would have to spread them out. I think some will be in the jury box, some will be in the gallery. It's going to be very different. There's no question about it, but we'll be able to do it. And I think with civil trials, it will be easier to accommodate logistically, because we only need 6 jurors. I usually pick 8. I bring in a veneer of about 25, and I can fit them into my courtroom and accommodate social distancing. So I think we're going to be able to get to civil jury trials sooner, perhaps, than criminal trials. Of course, criminal trials have priority, but assuming district judges are available, I think we may be able to get to civil jury trials sooner.
And the other question I thought is, you've talked about the numbers, whether we need to, for a criminal trial in particular, whether it just means we have to spend more days doing it so that you're bringing in fewer people on any given day. When I did a 4-month prison gang Vicar RICO criminal case, we started with questionnaires. I mean, there were 400 questionnaires that were sent to narrow that pool. And then you kind of do a narrowing and you bring people in kind of slowly over time. But back to Judge Beeler's point, all this just means it takes more time to do things that I think it probably takes twice the amount of time to do so many things that we were doing much more quickly.
So moving beyond jury, I guess I have a 2-part question. Moving beyond jury trials, is there anywhere else where you see sort of problems arising as you turn up the dimmer, as you put it, Judge Gonzalez-Rogers? And then once we're all the way back to normal, whatever that is, what, if any, changes do you see as being permanent?
Well, the other jury that, we haven't talked about are the grand juries. And certainly the U.S. attorneys are very anxious to get their grand juries working again. And so that too is a topic that is, you know, hotly being considered and negotiated, and we're trying to figure these things out. The people that I'm concerned about that we haven't talked about, it's not so much in the bailiwick of the California lawyers, are all the people without lawyers. Now, we have a help desk that we fund in each of our divisions, so that people without representation can come in and get some measure of legal help. And all of that's gone away at this point. They're trying to do things by phone, but when a person has a stack of papers, it's really hard to do that if you're not in person. And it's hard to do it by video because they may not have a computer. So I think we can't forget that we've got a large population of pro se litigants who need access to the courts too. And we've got to make sure to figure out a way to give them access in a meaningful way. And we have a big pro se prisoner litigation piece as well, and that's you know, we've had to slow that process down significantly too. So, you know, those are constituents of the courts who don't have a lot of representation by outsiders asking us to do things for them that are an important piece of the puzzle.
On that note, with respect to pro ses, we don't have a help line like you do, but even I'm hearing from prisoners that even the prison law libraries are closed. So not only are they unrepresented, but they literally don't have access to any way to do legal research right now. And we have a great public law library here in downtown San Diego, but I'm sure it's closed.
On the pro se litigants, I think that's a really good point that Judge Gonzalez Rogers is making, and it's something that we're sensitive to. For myself, and I think many of my colleagues in the Southern District, we tend to be a user-friendly courthouse, and so we get a lot of phone calls in chambers, and they go to my law clerks. And I had a pro se matter last Friday, and it was on a 4M dismissal, and he wanted to be heard. So we gave him the opportunity to either call in or come in person if he was comfortable. He wanted to come in. So he's the only litigant I've seen all week, but it was a way to accommodate, and it's very, very important that we do that as a court.
And as to that second point, do any of you have any thoughts on what, if any, permanent changes will arise from this?
Well, we've been talking about the video conference settlement conferences. I suspect that there will be a lot of pressure from practitioners and parties to extend that after we have reopened the court for in-person participation, because it's a big cost saver if the attorneys and the litigants don't have to come in person, if there is an equivalent that has been demonstrated to be effective. If our numbers show that the magistrate judges can settle cases through a method that doesn't involve an in-person appearance, I think there will be a lot of pressure upon the court to extend that.
We heard that there still is just the same number of cases being filed, at least not a large drop. So we wanted to know.
So to the contrary, I think filings are up.
Well, that makes this even more challenging. Is there a certain amount of time that that you're considering for schedules for new cases, given the circumstances?
Personally,
Ours is all driven by we sort of have, you know, our initial case management conference driven by, you know, the standard 90 days. I think things are being calendared, they get calendared automatically. I think everybody sort of commented a little bit about how do you schedule discovery, and you always have to have a meaningful, you always you have stage one discovery, which is discovery and round one settlement talks. Don't spend too much before you have a meaningful opportunity to schedule. I think everybody's already talked about how important it is to push back on a knee-jerk have to have a depo in person. I think the lawyers are already changing. They've already changed in the past month on their and are much more willing to accept and understand that they can do things by video deposition and it's going to be okay. So I don't see, and I think Judge Gonzalez Rogers said sort of, and I think you said the same thing, Judge Burkhardt, in the Southern District, initially a round one continuance, of course, and we have to, business has to go on as usual. And lawyers have told me that they welcome the ability to continue to do their work, because after all, people do need to have clients and get paid and advance the civil litigation in the court. So I have a feeling that it's going to be okay. I don't see any big lags on the civil side, except for jury trials until we figure that out.
Yeah, I think I mentioned earlier, I think people are gonna ask not to have to send courtesy copies of papers. I know they've already asked on the criminal side because I meet with those folks regularly. And perhaps that's a good sustainability issue. I have never liked to do CMCs by telephone, only do it very rarely. So, you know, but I'm fine with video. And so I think that we'll probably see more of that. Now, of course, right, it's all a funding issue. I mean, we didn't have a need to pay for licenses before we could no longer have courthouse appearances. And so part of this too will be, you know, where's all the, is this a resource? Are we gonna fund this as something that's important? So those are the two things I think that come to mind particularly.
I think one of the big changes that may be permanent is in civil cases is telephone conferencing. In our district, there's been a custom of whenever we have oral argument of people showing up in person. And it can be quite a endeavor where if you have a heavy summary judgment motion in a big case, it's not at all uncommon to have a team of 10 people show up with 5 or 6 lawyers, paralegals, and someone to run their PowerPoint, all of that. With telephone conferencing, what I'm finding is you might have the same number of lawyers appearing on the telephone, but only 1 or 2 speak. It's very orderly, it's very efficient, you're getting all of the arguments in. And I think it's a real savings to the clients. You don't have lawyers traveling and flying about, but participating very quickly via telephone. And that's a medium that I find to be very effective, and it really works in a law and motion context. I think also where we may see a big change, and the Supreme Court did this yesterday, they've gone to real-time audio. That's a game changer. We're not there yet, but we do a lot of telephone conferencing. And I think what is new, and I think is going to be fairly common in both civil and criminal cases, is the ability for the media and the public to call in. So I've had several cases. I have one going on today and a separate one yesterday involving media and the public. And they really appreciate this private line. They call in, we give them an access number. It's muted, so we don't hear them, but they hear us, they hear the court, and they hear the litigants. And through that medium, the media and the public are kept up to speed. And I think not only the media really appreciate it, but lawyers like it. So I have counsel on related cases who are interested in these arguments. They don't have to, in the days where you could show up and come to court and listen to argument, they don't have to do that. They can just dial in and hear the argument. So it's very efficient. I think going forward, we're going to see a lot more of that.
Do you have any words of wisdom for litigants as they navigate these uncharted waters?
Well, I would ask lawyers, you know, these are words of wisdom for pre and post coronavirus. Try to resolve the little things without having to come to us. It just, you know, I think as we've tried to communicate, we're actually dealing with a huge number of issues other than our own dockets. The ability of lawyers to come in and say, look, we've debated all these issues and we agree on a schedule, it is really appreciated. I mean, and I'm not saying that in an insignificant way. If I have to spend half an hour working on your schedule, I'll do it. That's my job. But to the extent that you can all agree on things and free us up to do these other things that are really important in a constitutional sense, we would really appreciate it.
Mine would be related to that. You know, you hear again and again that a crisis like this brings out the best in most people. Doesn't bring out the best in everyone, but it brings out the best in most people, and it puts things in perspective. So my advice would be, would reflect back what I've already seen, which is be kinder to each other. Keep things in perspective. Working together on a schedule, working together on solutions to problems that were never problems before. And we have definitely seen that in the Southern District. I've seen it in civil litigants. I've particularly seen it in the criminal bar, the prosecutors and the criminal defense attorneys. Just the demeanor is different in court. There's a more accommodation, more civility, and I would like to see that attitude carried forward. Even as we emerge from this, it would be wonderful if some of that were retained.
Judge Sabraw, any words of wisdom?
Well, I couldn't agree more with my colleagues. I think communication and civility are the key. These are unprecedented times, and like Judge Burkhardt, I am so impressed with the litigants who appear before me. They have been unfailingly courteous and respectful and considerate to these times and to accommodation when appropriate. I mentioned the civil bench trial, and that's just an example of what I see time and again, where counsel communicate, they work together, they submit a joint motion to the court that's reasonable, continuing the trial date for good reasons. And that goes such a long way. It's noted by the court, and I think it's the only way to practice. So I would urge counsel to communicate with each other, communicate with the court too. In our district, it is routine for lawyers to call chambers and speak with the law clerks on matters of scheduling, not on the merits, but scheduling related matters. So communicate with us and be civil and courteous. What I have found is here, of course, you know, this is an adversarial process, of course, and we all have different roles, and people can really go hard at each other on the merits. But what I have found is all of the stakeholders, whether they're prosecutors or criminal defense attorneys or civil plaintiffs or defendants, everyone has their oar in the water, and we're all rowing in the same direction. I mean, there's a real recognition that first and foremost, we have to do what's right under the circumstances and look out for each other's health and safety. And so I've found here in the Southern District that that's exactly what attorneys are doing. And that can only be done when counsel are communicating and being civil.
Judge Beeler, is there anything particular that we could let practitioners know that would make your life easier?
You know, everyone sort of has covered this ground, but just to echo some of those points, I went to Bowdoin College undergrad, and we had a spectacular president named Barry Mills, and he had something called the Barry Mills Manifesto, and it said something like, part of it, commit to the common good, the world needs you. And it's such an important thing, and that echoes the adversarial comment. Of course, we advance our individual interests, and that's okay. That's the adversarial system. But there's a lot we can do to commit to the common good. And I think the system needs lawyers to do that. And I think people are rising to the occasion. And that does make our life easier if we all work together on what can be done collaboratively and focus our adversarial efforts on what really needs to be argued about.
I just want to echo that point, but the other way around. I mean, it's become clear to me on this conference and before that the federal courts have really risen to the occasion, and it's just amazing what you've accomplished in so little time with such significant changes. So I want to first thank you collectively for that, and then second, thank all of you for participating and taking even more time out of your schedule to participate in this and help give practitioners some guidance and some insight into what's going on.
It was great to also work with, one of the things I like about my committee work is the opportunity to work with other districts. And so it's a nice opportunity to get together in a forum like this to talk with about our respective practices. I think it helps us all do our jobs better.
I agree. I've learned so much from my colleagues in the Northern District. I think I'm going to have to change my ways.
It's been a pleasure, really. And as I said, Judge Sabraw, I've served with your at least family members in the Northern. Glad to finally get to meet you. See, by video, I would not have been able to do that if it was just on the phone. I mean, it would have been different.
Yes. Well, it's my pleasure. Thank you.
Judge Burkhardt, it's good to meet you as well. And attorney, you folks for putting the whole thing together. I think it's a really important thing to do and to make sure we're communicating with members of the bar.
It was great. Thank you.
Thanks, everyone.
Thank you, everyone.
Thank you.
Bye.
Thanks, everyone.